Good day, everybody, and welcome to this episode of Not Just Business. Today, we're going to talk about arguments and disputes and conflict. This is the first episode since the coronavirus lockdown, and obviously the potential for conflict is far greater, especially for the many people living together in apartments and confined spaces. And of course, in the business world in general, because of competition and competitiveness, and of course, egos and emotions, conflict arises and is usually not dealt with very effectively. So I'm very privileged to be able to speak today, albeit telephonically, with Siham Boda, a professional mediator and advocate, and I might add, a very good friend. Welcome, Siham.
Hi, Derek. Thank you very much for having me on your show.
It's an absolute pleasure. Siham, you are a qualified advocate and more. You've studied on 3 continents. You've got 3 master's degrees. You're the most well-traveled person I know, by some distance, in fact, probably more than Queen Elizabeth. And you, of
Not
course,
quite.
and you're many decades younger. So you've done everything from organized crime busting with the elite Scorpions to litigation to working in the International Court of Justice in the Netherlands and in the Constitutional Court in South Africa. So, of course. So you were destined to reach the highest level of justice in South Africa. I could easily have imagined you sitting on the bench of the Constitutional Court one day. So,
well, that's a very lofty goal, I'm afraid.
So that's a hell of a resume. And then you changed track. Tell us about that.
Well, Derek, I think from the outset of my career, the thing that interested me about law was for people who are involved in some sort of conflict or dispute to feel like they've achieved some sort of justice. Mm-hmm. And very early on in my career, I got the feeling that many of my clients, even those who did win in a court, did not feel that sense of justice. The monetary outlay, the emotional exhaustion, and the time involved just really did not make them feel like they'd won anything at the end of the day. And I just thought there has to be a different way. And I did a little bit of research. And that's how I stumbled upon appropriate dispute resolution mechanisms.
Okay. And then you trained yourself up as a mediator, somewhere along the line.
Well, I'd like to say my path was as linear as that. It was, as you described when you introduced me, which made me sound a lot more profound than I am. But really, my career was not a linear path. It was the idiomatic expression of the garden route. It was basically where opportunities presented themselves and I was available and I wanted to have or gain that experience and I went for it. And that was very much how I fell into conflict resolution. I was a little bit despondent with my career where it was. I felt that the legal profession was not managing its cases in a very innovative way or a very dynamic way. And the actual managers in legal departments, I felt were not managers. They were incredibly good technicians. They were very good lawyers or litigators, but they weren't very good at managing people or people's emotions and especially their clients. So that's when I registered to do an MBA, and that shifted my exposure and experience to a variety of professions of my colleagues in the class, and also where I could explore soft skills courses such as facilitating people, negotiation, conflict resolution. And that is really the window that opened up this new understanding of resolving conflicts and disputes to me.
Have you ever looked back?
Well, I can't say that it was a clear-cut path into mediation because sadly in South Africa, our commercial landscape hasn't been very receptive to it. So I've had to hold on to my other skill set in order to just remain financially viable. But I feel now, especially with the introduction of Rule 41A in our Uniform Rules of Court, where there is a requirement for parties in litigation to have explored mediation and provide reasons as to why the mediation didn't work. I feel there might be a little bit more of a motivating factor for parties to be involved in mediation.
Okay. So, please help us with a bit of the technology, rather the terminology. There's conciliation and mediation, there's arbitration and litigation, and many people don't really know the difference. Even some legal people, I believe, Can you distinguish amongst these various methods of resolving disputes, please? And tell us what are the pros and cons of each?
For sure. Most lay people have a problem. They want it to be resolved. And then lawyers get involved and issue, oh, well, no, this needs to be done and a subpoena needs to be done and a letter of demand. And before you know it, you're in a whole legal rigmarole. And the person was just like, listen, I'm in this conflict or I have this dispute and it needs to be resolved. Very few lawyers will go through the array of tools in their toolkit to say, listen, we could have a negotiation, which is a really informal process. It's voluntary, it's flexible, it's informal. And, we can have this negotiation. We can invite them to it without any legal ramifications and have a discussion, see where it will go. That would be your least invasive method of an appropriate dispute form of resolution. Then you can up it a notch a bit where you go for conciliation, which is very similar to mediation, also voluntary, flexible, confidential processes, very much focused on the interests of the parties. Conciliation is a little bit different where they put forward proposals to parties as to how the dispute or conflict should be resolved. Mediators are a little bit more active in managing the process of the mediation, but they do not put forward solutions to the parties. Mediators believe if the process is managed well, the parties will reach a solution that's sustainable and viable and will work for them.
Okay.
And that is the main difference between a mediation and a conciliation, but also a lot of the favorable attributes, that being that it's voluntary, unless, of course, it's in a contract or in a piece of litigation which compels mediation. It is flexible, it is confidential, so that those are really great attributes of a mediation, a conciliation process. During this COVID time, I've been able to continue mediating using Zoom because the process is that flexible. It doesn't require notices to be delivered or any of the other cumbersome aspects of litigation. And that brings us to the other side of things, which is litigation. So litigation is a very formal, structured process. The rules are set out in terms of the uniform rules of court, when you serve, what you serve, how things are paginated, when you discover. It is a public forum. So if you've got a dispute, it will be in the public domain. You've got a judge who sits on the bench, and it's very much legal based. The judge will rule as to what the outcome is of that dispute. Whereas if we go back to mediation, you can choose your mediator. It can be mutually agreed by the parties. And the outcome isn't only legal based. It takes into account other interests like financial interests or relationship interests, which don't really come to the fore in a strict legal process. And then if you look at arbitration, it's sort of a midway between mediation and litigation. It's not as formalistic as litigation, but it is fairly so. You can choose your arbitrator as you can your litigator. And some disputes require that because they need someone of a particular technical expertise to assist in resolving a dispute. And the arbitrator makes a finding and award, and that resolves the dispute. But you still have your legal representatives, you still have your evidence, you still have your documents which need to be paginated. So it's procedurally still quite heavy, but you do get to choose when you want your arbitration and who your arbitrator is. Whereas in litigation, you don't know who your judge will be. It will be whoever's next on the roll. And you can't really choose your time as well. It's just when there's the next slot on a roll, which could be anything from 6 months to 12 months, depending on the jurisdiction.
So I take it arbitrations aren't open to the general public.
Yes. So, for example, conciliations, negotiations, conciliations, mediations, and arbitrations are all private. And their outcomes are private. So, their awards remain closed, or their outcomes or their settlement agreements or whatever the outcome of the process is remains closed. Litigation, of course, it's public. Anyone can attend, and the outcome is public and it's reported. And as I mentioned before, mediation isn't the be-all and end-all. for me, it's very much appropriate dispute resolution. You've got a dispute in front of you. You need to choose your lane and figure out which is the best mechanism, taking into account cost, time, the interests that are at play, and the nature of the dispute. So when you consider all of that in concert, you then look at the various forms of dispute resolution available to you and you go, okay, for this particular dispute, I would say this is a good process.
Can you perhaps give us a hypothetical example about a matter which might be suitable for mediation and one which might be suitable for arbitration and one which might have to go to litigation? Just off the top of your head, and that's a bit...
Sure. Let's deal with the litigation first. So, for example, if something occurs where there's imminent harm or imminent damage, like maybe a huge factory's sluice gate has ruptured and a river is being polluted, you want to get to court as soon as possible and get an urgent interdict to stop that from happening. So in that instance, litigation would actually be a great tool because you can get on the urgent roll and say, this is what's happening. This river is being polluted. It's going to contaminate the water for an entire town. It's a health risk. This needs to happen now. We need action now. So litigation there would be a very good mechanism to use. Also, it's in the public interest. You want a public reason to come out because it's in the interests of justice and you want to build your jurisprudence in that area. So in that instance, I would say litigation is a really good process to select.
So, for instance, if you want to set a precedent and say, this is now part of case law and sort of that becomes law of itself. Am I correct?
For sure. I mean, one of my really nice roles that I was privileged to occupy when I worked with the DSO or the Asset Forfeiture Unit more so, there was quite a lot of uncertainty around the legislation that we had. And one of the briefs I had was to select cases where we can litigating obtain clarity of how that new legislation was to work. So sometimes litigating is necessary because if you look at the primary function of law is to provide certainty to people. They must be able to say, okay, this is the law and this is how we understand it to be with very little ambiguity. So in that sense, for sure, if litigation is necessary to achieve that, then that is the appropriate process.
Okay. I suppose the judge, you don't pay for the judge or the courtroom, you pay for whatever the outcome is or not. And for arbitration, I assume somebody's got to pay for the arbitrator and the venue for that matter.
Yes, it does make it a much more expensive process, but it's particularly appealing to commercial disputes because commercial disputing parties often want to resolve a case very quickly and sometimes waiting for a court roll to be available, and there might be a postponement, and they prefer the certainty of selecting a date. Yes, it is more expensive. You have to pay for your arbitrator as well. And also sometimes they might want an expert in the field to give them the outcome that they are in conflict over or in dispute about. And this is a slight criticism that has sort of emerged in the South African realm recently, is that our really most, talented advocates are either involved in representing parties in arbitrations or they are sitting as the arbitrators. And you've got all of that legal expertise concentrated in the private realm. And we don't get to see their papers and we don't get to see the awards. So it's almost like, that's excluded from the public realm and it hasn't enriched our jurisprudence, so to speak. So that is a slight disadvantage of arbitration. But, in the scheme of wanting to resolve it, or if it's a very specialized, nuanced area where parties are disputing about, they might want a very technical response. So that might be attractive to disputing parties there. And then mediation is, quite flexible. You don't have to have an expert in the field mediating it. Sometimes it's better if you're dealing with maybe medico-legal dispute to have someone who's very familiar with the medical legal landscape or the terminology. It can be helpful, or someone involved with architecture or engineering in construction disputes. it certainly does lend an advantage, but it's certainly not necessary. Yes, you do have the added costs of paying for the mediator, of paying for the venue, but it's generally a much shorter process. Arbitrations can go on for quite a number of days, sometimes weeks. Mediation is seldom more than 48 hours. It's seldom more than 2 days. You might break it up as a mediator where you have pre-mediation meetings and then a mediation meeting coming together. So in all, you might have 4 days broken up over 2 weeks or something like that. But it's a lot less time consuming, I believe, than arbitration or litigation.
Okay.
So I hope that gives you an answer. You wanted a bit of an example where mediation can be used, and it is in a vast array of arenas. The most familiar, I think, people are with family mediation matters because it lends itself very much to that area. But I enjoy workplace mediation. That's my favorite type of mediation. Commercial mediation is fantastic, especially for small businesses and entrepreneurs. I can't encourage and advise them enough to please put mediation clauses in their contracts. They think arbitration and mediation is the same thing. So if I can give all your young entrepreneurs a piece of advice, please include mediation in your alternative dispute resolution clauses in your contract. Then, mediation can also be used in construction disputes, medical legal disputes, insurance disputes, and then community disputes as well. So the array is quite vast where it can be applicable.
Okay. So how does a formal mediation work? Describe what happens for those who don't know that might want to consider mediating an issue. What is this? How would they go about it? And what is the process?
Okay. So I think what you're asking is what can trigger a mediation?
Yeah, and then what is the process from there on?
For sure. So once you get to a point where you've recognized that you find yourself in the middle of a dispute, you can start initiating a mediation through a few processes. If you have a legal team in your corporation or organization, have a chat with them and say, okay, listen, we've got a dispute on our hands. This is what is going on. I'd like to mediate it. And they will then initiate an offer of mediation to the other party. If you're a smaller business and you don't have this, simply speak to the other party and say, listen, I see us having a dispute. I don't think we can resolve it on our own. Could we consider inviting a third party to assist, a neutral, objective third party to help us resolve the dispute through a process of mediation? Okay. And then how do you select a mediator? There are quite a few organizations in South Africa that have accredited mediators. There are a number of people who call themselves mediators, but they haven't been trained. So I would be a little bit cautious around involving them because it's not clear how much training they've had in the process and whether they conduct it professionally or not. Okay. So there are a few bodies in South Africa that have accredited mediators as part of their membership panel. And usually selecting one of those is pretty much a safe bet. So now you've decided on a mediation. Both parties have agreed to the mediation. You then select a number of mediators and decide between you. You put forward 3, they put forward 3. You then come to a sort of agreement about who you're going to go with. You then initiate a contact to that mediator. Hello, I'm Derek Peed. I've got a bit of a problem here. Could we please instruct you to be involved in a mediation? And then usually the mediator puts forward their professional profile. So it's an introduction to both their parties. And then the mediator will take the process on from there. As a mediator, your most important role is to manage the process. And you need to do that from the outset of your engagement with the parties. So, for example, how you initiate your first contact, how you introduce yourself to your parties has to be incredibly partial and fair. How you speak to one party, you must ensure you do the same to the other. I was quite surprised a number of years ago where I represented a party in a mediation where a very experienced mediator actually lapsed on these things. And he created a lot of uncertainty and anxiety for my client because my client felt he was having conversations with the other side a lot more than he was with us, and reaching decisions and making decisions and imposing them on our side without having discussed them with us. So how that initial relationship is managed is incredibly important. So from the beginning, how you engage with your clients and the parties are very, very important. Include the legal representatives if they have legal representatives, because they can be incredibly helpful to the process if they are properly managed.
Okay.
Don't allow yourself as a mediator to be overwhelmed by a legal representative, especially one who hasn't been part of the mediation process, who's not familiar with the process, or tries to derail the process. So you need to stand firm and do your one and only job, which is to manage the process.
Okay.
Thereafter, it's up to you. Quite flexible in the process. Invite the parties to share information with you, to share documentation with you. I often like to have an impartial conversation with each party prior to the mediation. I let both parties know I'm going to have this conversation. They choose their time slot. I have a chat with them. It just sort of familiarizes me with each party. So when we meet each other for the first time, it's not like we haven't met before. We don't have a sort of a previous connection with each other. And, those times are really important to take the time to understand where the parties are coming from. We then have the mediation. It's a joint mediation. You prepare them for the mediation. Part of the mediations which have not been successful is because parties and mediators are not adequately prepared. So if there's adequate preparation, which should be led by the mediator for the process, then the outcome is usually quite successful.
So just on that point, what kind of preparation would you do and with whom?
Okay.
Would you, for instance, I assume you'd talk to both parties. Would you talk to the legal representatives as well?
Right. So for the initial part of the mediation, I will first explain the process to them because I can't presume that they have been part of a mediation. Also, as I've mentioned a few times before, that the mediation process is flexible and each mediator often develops their own style. So I think it's important to just let the parties know of how you intend running it, what they can expect, what markers they can expect in the process, sort of route mapping it for them so that they don't feel overwhelmed or don't feel like something has been foisted upon them that they're not prepared for. One of the things I'll ask parties to, in terms of preparation, is to share what they think are pertinent documents with me. And for me as a mediator, it's interesting to see who shares what and where the Venn diagram sort of comes together and documents are shared by both parties. I then have individual conversations with parties, both of which are confidential. I will not disclose the one conversation to the other and vice versa. Those conversations remain completely confidential. I then tell the parties to prepare for the mediation by preparing some opening remarks of where they think the conflicts are, of how they'd like it resolved, of what they'd like to see going forward. The one thing I like, and I forgot to mention when we spoke about this earlier, for me, the most profound difference between mediation and litigation is that mediation is forward-looking. Here we are, we're going to try and resolve what we have, and we want to find a way that we can move forward that is satisfactory for both parties. Litigation is more forensic in nature. It looks backward. It looks at what has happened. It picks it apart, who was right, who was wrong, rather than developing a relationship or nurturing a relationship for the parties going forward. And for me, that is the most profound difference between the two.
Okay.
And that is why I try to get the parties to prepare their opening remarks with a forward-looking trajectory in terms of resolving the dispute. Then we have the joint mediation session at an agreed place. This is all part of the housekeeping that I will do on the side, either with the legal representatives or the parties themselves, getting them to agree where they'd like to have the dispute, who manages my costs, and how we're going to deal with all of that. I will also prepare mediation agreement. I will not mediate or commence the mediation without the mediation agreement being signed by both parties. That protects me as well as them in terms of the confidentiality of the process. Once the process then commences, I might choose to stop the mediation and have a side session with one party or the other party. And those side sessions also remain confidential and ring-fenced, unless I've been expressly permitted to share some information with the other party. I will not. I might indicate to a party that, you know what, I think if the other party was aware that you felt this way or aware that you're facing this sort of challenge, they might be amenable to another discussion. And I'll ask them permission to share that piece of information, only if it's appropriate. I mean, I'm not a postman between the two parties. Mm-hmm. If it's appropriate or it will add value to resolving the dispute, then at least I know I've been given the authority to share that information. We then get to a point generally in the mediation process where we're moving towards exploring solutions. And that's when I like bringing parties together, looking at how they can explore solutions, because people can put forward what they're capable of. And this is where, your skill as a mediator gets tested. You might not provide the solution, but you can test the solution. Mm-hmm. Mm-hmm. So, for example, sometimes a party will get very frustrated and they'll say, okay, fine, I'll just agree, we can do this. And then I'll say, okay, you want to settle on 20 million rand? Do you have 20 million rand? How do you plan to pay 20 million rand? I mean, I've had that in a family dispute where one party agreed to pay a large sum of money just to resolve a dispute. And we had to just go through the nitty-gritties of saying, actually, I don't have that amount of money available right now. So it's not a really nice good solution. Yes. So, you will then explore the solutions. I had a solution with a technical company where they had to hand over some IP. So how that was going to be done needed to be managed quite specifically because of the technical concerns around the information being exposed. So you need to be able to test them and say, okay, well, how are you going to do that? How are you going to ensure it's going to be safe? And, that sort of thing. So we get to a point where it's quite sustainable. I don't know if that's helpful.
Yes.
And then after that, we get to the solution phase where we craft the solution. And this is where the legal representatives can be incredibly, incredibly helpful, because already as you're starting to get to this point, you can get the legal representatives to work together and say, listen, don't you want to sit in the side room and start hammering out an agreement that we can come up with? Even if you don't have an agreement, what I often have is a memorandum of understanding that we are in principle agreed on the following clauses, and we are going to come up with a settlement agreement that will go through a few rounds and we'll meet again just to sign. And we usually have timelines sort of in a week that this will be done. Sometimes they invite me along to just go through each clause of the settlement agreement to make sure that they are actually on the same page, and then we resolve it. And then, of course, there's the option that that settlement agreement can be made an order of court.
I was just thinking, those family matters that you talk about being mediated. Usually there's a lot of emotion in things like that. For instance, divorces, which are under normal circumstances, I suppose, would be ideal for mediation. But people, some people want to win, they're angry, there are all kinds of things going on. So it might look as if your mediation is faltering. And then I know mediators use this tool called a reality check. Tell me how that works and how effective it is.
Yeah, so family mediation, divorces and that sort of thing is very well suited to the mediation process. And whether it's a family mediation, a workplace mediation, commercial mediation, it might feel like you're a bit stuck in the mud at some point where either parties are sort of really digging their heels in and you can't get any movement, or you're just circling around on the same issue over and over again. And I find a useful technique, especially in commercial mediation, is to do, as you say, reality testing. And that is simply saying, well, if you don't agree today or come to an agreement, what is your alternatives? And you go through those alternatives. Your alternative is then to litigate, or, for the relationship to deteriorate further and no supply and your business to deteriorate further. So you basically go through a list of alternatives to reaching a negotiated agreement in the time that you had set aside for your mediation process. And a really nice one around the litigation reality testing is to ask the parties what they think going to litigation involves. And once they're like, well, we'll brief a lawyer and then we'll go to court. And, they think it sort of happens like it does on television. And then I bring them back to our South African reality of, okay, this is how long it's going to take to get a letter of demand, followed by a subpoena, followed by briefing an advocate, getting your particulars of claim done, waiting for them to do a plea, and literally going through the whole process. And then I have a little calculator on the side saying, and this is how much every one of these things is going to cost you. And then I've got a calendar on the side of that going, and this is the timelines we're looking at in terms of best case scenario. And that usually sort of maybe moves them. And then the bit that really, a lot of them don't think about is the emotional investment. I said, this is going to take you away from your desk. You're not going to be developing research and development for your products anymore. You're not going to be client facing because this is going to consume you. And it's going to take up so much of your precious time in advocates' chambers with your lawyers, discussing things, giving testimony, preparing evidence, and then it's going to really tire you out emotionally, which you're not going to even factor in. And I had one CEO tell me, oh, I'm being hoppy skippy. And they decided not to proceed with the mediation. And 2.5 years later, I ran into him as I was leaving court. And he said, you were so right on the emotional toll it takes on you. I thought you were being a silly young woman, and I underestimated that piece of advice you gave me. So, yeah, that's not to be underestimated.
I read somewhere that the average commercial litigation takes roughly 2 years of senior executive time. So that's also something that people don't factor in, is how much of your own. 2 years of senior executive time is several million nowadays. So you must add that on your calculator.
And of course, your business is the poorer for it because it doesn't have the tension of that person whose expertise you hired not to be a witness in a case, but to actually contribute to your business. And I think that was when I was doing my MBA, I really realized how litigation actually doesn't respond well to the business world. It takes too long and it's too expensive. If it's one industry that's needing disruption and innovation, this is it.
Yeah. So tell me, what are the 3 most important lessons that you've learned in your experience as a mediator?
I think the first one, and it's a constant learning battle. I'm certainly not proficient at it by any means, but that is to listen with curiosity and to really listen to what people are saying so that I can help to understand what their underlying interests are and asking appropriate questions. So I think those 2 probably go hand in hand. And then I think the third is patience, patience with the parties and patience with the process and patience with myself. So I think those are probably the 3 most important skills: listening, asking really appropriate questions, and to be patient.
Okay, I was thinking you also teach mediation. I know you do, also to the Law Society. And, I was always under the impression that lawyers don't ask questions for which they don't already know the answers. That's just the way they're hardwired. So how well do lawyers adapt to mediation?
Well, the first few days of the training is always interesting because you have what I call the Jack Russell mentality, where everyone wants to say their clever thing very quickly and sort of dazzle the audience. And I think that is probably where they struggle the most, because lawyers are sort of taught that people come to them for their advice.
Mm-hmm.
And so they must have something to say,
Mm-hmm.
and they're there to help people. So taking on a more actively passive role is quite difficult for them.
Mm-hmm.
Just listen, because they feel like they need to be contributing and, advising. And so I think just being able to be still is probably the most difficult role for lawyers. The second one is the types of questioning technique, obviously, because lawyers are taught to engage more in closed questioning style, because that's very good for cross-examination. You don't want some long, windy narrative on the stand. And switching to a more open style of questioning is a technique that some lawyers do struggle with. So I think those would probably be the two things I've observed where lawyers struggle to adapt to. Yes.
Okay, makes sense. So you've mentioned earlier that I think it was Rule 41 you mentioned, where now people are required to go mediation route first.
Yes.
Before clogging up the courts. So what needs to change? Because I always have this opinion that you've got this testosterone in the boardroom and people just want to win. It's power struggles don't lend themselves to mediated solutions. What needs to change in corporates for commercial mediation to become more mainstream?
I think it is very much around the leadership style, because they, at the end of the day, are making the decisions. They sign the checks. Okay, they do the EFTs. I'm a bit old school. At the end of the day, so they're the customer. And they should be able to indicate the process they want to choose. Unfortunately, some of them see mediation as being a very weak process. Let me tell you, without fail, every executive I've mediated with after the day says, I am so thoroughly exhausted. They never quite prepare themselves for how engaging the process will be. So just to answer your question in terms of what needs to change, it's the leadership style, to request it, to let them know that it's available. Lawyers often think that mediation and arbitration are the same thing. So I can't imagine, just normal business people also conflate the two. They don't know that there's a difference between the two. So I think it would be a little bit of education, advocacy, awareness about it will allow executives to think differently about it. A lot of them think it's the CCMA, which is our labor dispute resolution mechanism. And I mean, there are elements of it, but it's quite different when it happens privately.
Okay. So differences of opinion and interpretation obviously arise daily in families, in business, etc. So often
it would be very dull otherwise, Derek.
So often leading to disputes flaring up. Is it a good or a bad thing? That's my first part, that differences of opinion cause conflict. And B, how should parties deal with these differences before calling in professional help?
Okay, so I think the exchange of ideas, difference of opinion is vital to progress. Sharing different viewpoints is incredibly invigorating, I find. It's very much on how people go about it. And if you've got one party who's very adamant that they cannot be wrong, or it's their way or the highway, that sort of attitude, that's where you're going to have a dispute emerging, sort of a conflictual space, because you can't get over that hump. And depending on how you engage with each other from there on, that will set the trend. Are you going to engage in behavior that's going to escalate that conflict, or are you going to engage in behavior that's going to de-escalate the conflict? The easiest way to try and de-escalate that conflict is to start asking questions, to deepen your understanding of where that person's coming from. That's probably the best way to lower the temperature of that particular disagreement or argument. And the funny thing is, you might actually learn something. So I would say that is probably the best way to try and de-escalate behavior. But I mean, we see it not happening a lot. And it's mostly because people are either feeling very insecure, so they feel they need to shout the loudest to get their point heard or their point across.
You just need to look at our parliament, for an example.
for example. Or in boardrooms, I mean, I've mediated between members of boards. And there you often have egos at play, but they're also quite lonely because they've got no one else to speak to. And then they get very adamant that their way is the only correct way. But they've just sort of lost trust in having a conversation with each other because maybe trust has been abused or used against them. So you need to, as a mediator, then engage in some trust building exercises and then see how you can move forward mediating whatever the dispute is. But it's generally our own human foibles of ego, insecurity that prevents us from resolving a dispute. Admitting that you might be wrong is hard.
As a coach, I would say if you feel your body temperature rising, and you should become a better observer of yourself, just in general, if you want to be successful in life. So know what triggers you, know when you are triggered, and find a way to cope with it. For instance, just a few deep breaths, keep your feet flat on the floor. Don't let people wind you up. It takes a bit of practice, but anybody can do it.
No, it is. And it's a constant practice because you might think you've pretty much got it waxed, and then you'll have a day that you starts off where everything that could possibly go wrong does. The alarm doesn't go off, the dog gets sick, your kid hits their head, there's a 16-wheeler truck that's crashed, you get to your appointment late, you're slightly disheveled, you're not in a very calm state of mind. And on that day, you then have to engage with a conflicting employee or a staff member. So it might not be your best day to try and self-manage oneself, but that is the day you've got to look at to see on that horrible day, how would I manage conflicts and take it from there. And it's a work in progress. Sometimes you get it right. Sometimes you could do better. So
it often helps also to call a break. So, okay, guys, temperature is getting a bit hot here. Let's just take a tea break and come back in 15 minutes or so. That often people become a little bit more rational when they've had a bit of a break and maybe think, well, maybe I shouldn't have said that. So taking a break is recommended in circumstances like that.
Very much so. And that goes to one of the things that I didn't maybe touch on with a mediator who manages the process. I mean, she has to really be aware of where the parties are, their energy levels, when they're getting tired, when they need a bit of a break, a snack, a leg room, a bit of a leg stretch, and that sort of thing. A mediator needs to be profoundly aware of where the parties are at all times by watching their body language and their ability to contribute to the process. So that would be very much the case. And, some people express emotion during a mediation. In a court case, they won't really have the chance to do that, but they express their emotion or their anger. And a mediator must be able to absorb that and reframe that so that it doesn't derail the process and get the other party to walk out the process. So, a mediator must really be able to read what's going on and be able to have a certain level of comfort with conflict because they have to manage it when it does arise.
Well, this has been the first episode that I've done since the coronavirus lockdown. And if I never hear either of those two words again, it'll be too soon. So thank you very much for your time and your experience. It's people like you that give us hope for the future. And we wish you all the best in your future endeavors.
Thank you, Derek. I've been loving hearing and listening to your series and all the really inspiring people you've been interviewing, and I wish you much success with it.
Thank you. For those of you who would like to comment or get in touch with either Siham or me, please leave a note on the podcast website, www.notjustbusiness, that's with hyphens, not-just-business.com, or email me at derek@derekpeed.org. Thank you for listening.